Declaration of Independence, Thomas Jefferson once wrote, "All people are endowed by the Creator with certain unalienable rights. Civil liberties are those rights that belong to everyone. They are protections against government and are guaranteed by the Constitution, legislation, and judicial decisions. Civil rights are the positive acts of government designed to prevent discrimination and provide equality before the law." The original Constitution mentioned specific rights considered to be fundamental freedoms by the Founding Fathers, which were writ of habeas corpus. You must be brought before the courts and informed of your charges against you. No bills of attainder. You cannot be punished without a trial. And no ex post facto laws, which are laws applied to acts committed before the law is passed, are unconstitutional. Two protections for freedom of religion exist: the Establishment Clause and the Free Exercise Clause. According to Thomas Jefferson, the Constitution creates a wall of separation between church and state. Because the church and government are separate in the United States, Congress cannot establish any religion as the national religion, nor favor one religion over another, nor tax American citizens to support any one religion. Controversy concerning the exact meaning and extent of the Establishment Clause has led to actions by the Supreme Court in defining the parameters of the clause. The Free Exercise Clause guarantees the right to practice any religion or no religion at all. In its interpretation of the Free Exercise Clause, the Supreme Court has made distinctions between belief and practice. The court has ruled that while religious belief is absolute, the practice of those beliefs may be restricted, especially if those practices conflict with criminal laws. There are several different classifications of speech. Pure speech, which is the most common form of speech; verbal speech, given the most protection by the courts; speech plus, verbal and symbolic speech used together, such as a rally, then picketing, may also be limited. Limitations on free speech have generally existed in the area of providing for national security. In 1798, Congress passed the Alien and Sedition Acts, making it illegal to say anything false, scandalous, and malicious against the government or its officials. Although these acts are aimed at the opponents of President John Adams and his Federalist supporters, others were convicted under these laws. The Alien and Sedition Acts were never challenged in courts, and they expired in 1801. After the assassination of President McKinley by an anarchist in 1901 and the entrance of the United States into World War I, Congress again passed sedition laws forbidding verbal attacks on the government, and states began following suit. These and subsequent laws were challenged in the court. Freedom of the press is often protected because it is closely related to freedom of speech. The press is used as a form of expression. Today, the press includes newspapers, magazines, television, and the internet. The First Amendment guarantees the right of the people peacefully to assemble and to petition the government for a redress of grievance. Freedom of assembly and petition applies to both private and public places, allowing citizens to make their views known to the government officials through petitions, letters, picketing, demonstrations, parades, and marches. The courts have protected these rights while allowing the government to set limits to protect the rights and safety of others. The Constitution makes no mention of a right to privacy. The Supreme Court, however, has interpreted several rights that might fall under the category of privacy. Several amendments of the Bill of Rights address the rights of those accused of crimes. The 14th Amendment extends those protections to apply to the states. Specifically, the 4th Amendment, search and seizure; the 5th Amendment, self-incrimination; the 6th Amendment, the right to an attorney; and the 8th Amendment, cruel and unusual punishment. Civil rights are guaranteed by the Equal Protection Clause of the 14th Amendment, which was added to the Constitution after the Civil War to prevent the states from discriminating against former slaves and to protect former slaves' rights. The court recognized that some forms of discrimination may be valid, like preventing those under 21 from consuming alcohol, and have therefore devised the rational basis test to determine if the discrimination has a legitimate purpose. The courts also developed the strict scrutiny test, a much stricter standard. If the discrimination reflects prejudice, the courts automatically classify it as a suspect and require the government to prove a compelling reason for the discrimination. For example, if a city has separate schools for different races, the city would have to prove how this serves a compelling public interest. After the Civil War, 3 amendments were passed to ensure the rights of former slaves. The 13th Amendment abolished slavery. The 14th Amendment defined citizenship to include the former slaves and provided for due process and equal protection, which were used by the Supreme Court to apply the Bill of Rights to the state and local governments. The 15th Amendment provided that individuals cannot be denied the right to vote based on race or the fact that they were once a slave. Until the 1950s and 1960s, states continued to use discriminatory practices to prevent African Americans from participating in political procedures. Black codes were state laws passed to keep former slaves in state of political bondage. The laws included literacy tests, poll taxes, registration laws, and white primaries. The Civil Rights Act of 1875 outlawed racial discrimination in public places such as hotels, theaters, and railroads, but required African Americans to take their cases to federal courts, a time-consuming and costly endeavor. The act was ruled unconstitutional in 1883. Jim Crow laws were laws designed to segregate the races in schools, public transportation, and hotels. In Plessy v. Ferguson, the Supreme Court upheld the Jim Crow laws by allowing separate facilities for different races if those facilities were equal. This created the separate but equal doctrine. In Brown v. Board of Education, the Supreme Court overturned the Plessy v. Ferguson decision, ruling that separate but equal is unconstitutional. In Brown v. Board of Education 2, the Supreme Court ordered the desegregation of schools with deliberate speed. The Civil Rights Act of 1957 created the Civil Rights Division within the Justice Department and made it a crime to prevent a person from voting in federal elections. The Civil Rights Act of 1964 provided discrimination in employment and in places of public accommodations, outlawed bias in federally funded programs, and created the Equal Employment Opportunity Commission. The 24th Amendment, 1964, outlawed poll taxes in federal elections. The Voting Rights Act of 1965 allowed federal registrars to register voters and outlaw literacy tests and other discriminatory tests in voter registration. The Civil Rights Act of 1991 made it easier for job applicants and employees to bring suit against employers with discriminatory hiring practices. With the success of the African American civil rights movement, other minorities have also pressed to end discrimination. Hispanics, American Indians, Asian Americans, women, and people with disabilities have all joined in the quest for protections from discriminatory actions as well. Throughout much of American history, women have not been able to get the same rights as men. The 19th Amendment gave women the right to vote. The Equal Pay Act of 1963 made it illegal to base an employee's pay on race, gender, religion, or national origin. This also affected the African American civil rights movement. The Civil Rights Act of 1964 banned job discrimination on the basis of gender. In Reed v. Reed, the Supreme Court ruled against a law that discriminated against women, deciding that the Equal Protection Clause of the 14th Amendment denied unreasonable classification based on gender. The Equal Employment Opportunity Act prohibited gender discrimination in hiring, firing, promotions, pay, and working conditions. The Omnibus Education Act required schools to give all boys and girls an equal opportunity to participate in sports programs. The Equal Credit Opportunity Act prohibited discrimination against women seeking credit from banks, finance agencies, or the government, and made it illegal to ask about a person's general or marital status on a credit application. The Women's Equity in Employment Act requires employers to justify gender discriminations in hiring and job performances. Last but not least, Affirmative action is a policy designed to correct the effects of past discrimination. Most issues of affirmative action are race or gender-based.